The 1982 court case Plyer v. Doe answers the question: can schooling be denied to children of unauthorized aliens? In 1975, Texas legislature passed a state law that allowed schools to charge tuition fees for children of unauthorized aliens. This code was passed as a part of a large routine education bill, and no record can be found explaining this amendment to education law in Texas. Enabled by the 1975 law, the school district of Tyler, Texas, under the leadership of District Superintendent James Plyer, began to charge undocumented children a tuition fee of $1,000 per year. The tuition rule affected the families of the 60 undocumented children in the Tyler School District. Made aware of the situation of immigrant children being charged for public schooling by a Catholic lay worker, a lawyer took on the case on behalf of 4 of the families whom the law affected. For the sake of privacy, the families were permitted to use pseudonyms, hence the case name Plyer v. Doe. The district judge appointed to the Plyer case issued an injunction which stated 2 demands. First, that Tyler schools admit all students regardless of documentation, and second, that the State Board of Education send funds to Tyler schools for all students. After going through the United States Court of Appeals, Plyer v. Doe ended up in the Supreme Court. There, in a close 5-4 decision, the Supreme Court ruled the Texas law unconstitutional, stating that it violated the 14th Amendment rights of the immigrant children. In the decision, the Equal Protection Clause was cited, which prohibits states from denying any person within their jurisdiction the equal protection of the laws. The court's decision stated that the plaintiffs were still persons no matter their immigration status. It was said that the phrase "within its jurisdiction" means that the 14th Amendment protects all those living within a state's borders and subjected to the laws of that state. Interestingly, one of the dissenters, Chief Justice Burger, stated that it is senseless for an enlightened society to deprive any children, including illegal aliens, of an elementary education. However, the Constitution does not vest in this court the ability to strike down laws because they do not meet our standards of desirable social policy. Justice Powell, one of the 5 who voted against the Texas law, addressed the fact that illegal immigrants will continue to come across our border, seeking opportunities and other benefits of living in America, and their children should not be left on the streets uneducated. Plyer v. Doe guaranteed public education to children of undocumented immigrants, which has an effect on the daily life of a classroom. Children of immigrants often do not speak much English and must also become assimilated to American school. This makes for a difficult transition, which teachers must be aware of. There is also the obvious effect on curriculum, which English language learners may initially have a hard time understanding because of the language barrier. This, too, is a factor teachers must recognize and work to minimize. As classrooms continue to diversify, teachers must continually work to create safe environments for learning that are able to meet each child where they are at. In conclusion, children of illegal immigrants cannot be denied access to public education. Education is a right afforded to all within the borders of the United States.